My lord, I am mentioning my hearing.
mention that contempt application Jalpaiguri matter. Lordship,
Yes.
kindly, my lord, be any day. Well, I have already mentioned file has come from Jalpaiguri. Only any day, your lordship, kindly let it be listed tomorrow.
My lord, I am mentioning of hearing matter, my lord.
Hearing, have you served notice upon the other side?
Yes, my lord. I have some notice.
Hand over the slip.
My lord, I am mention on matter of what will listed in other hearing. Hearing. I have served upon the opposite party.
Hand over the
To-
slip.
With your lordship's kind leave, my lord, this is a my lord specially assigned matter before a division bench led by my lord. The matter was taken up on 6th of December. Direction was passed toward exchange of affidavits, and a liberty was given to mention on expiry of such time. Time has expired, my lord. None of the affidavits have been filed. Lordship, may I have your lordship?
দেখে নেবেন division means
Mentioning upon notice.
My lord, may I have your lordship?
May I have your lordship to mention a hearing matter? We have intimated the other side.
hearing matter. I have asked you to hand
My
over
lord.
the slips,
My lord.
provided you have served notice upon the other side.
Notice is attachment.
Lordship, may I permit to mention? Lordship, there is a WPA 282.
What do you want?
There is a direction for exchange of affidavit. Affidavit has not been exchanged, and lordship have directed to mention the matter immediately after expiry.
You want inclusion in the list? Sir, I have said hand over the slip, provided you have served notice upon the other side.
No, lordship.
Then don't hand over. Yes, call the list.
Lordship, there is a direction to mention the matter after the.
Please serve notice, then mention.
Okay. Item number 4.
Yes. Where is the petitioner? Petitioner is not coming.
In fact, my lord, everything has been
Shows that order has been complied with.
complied with, my lord, but my lord, appointment has not yet been given, my lord. The file has been transferred, file has been placed before the for departmental approval, my lord.
You have filed a compliance report.
No,
File a compliance report.
and
The learned
in the month of February, my lord, because
Why?
it will take some time.
According-
My lord, they have informed me the district.
I'm
panchayat-
giving you 1 week time.
My lord, the district panchayat and rural development officer has informed me over my phone, my lord, that his file has been forwarded to the for departmental approval, and it will take at least
Then it is yet to be complied with.
only appointment letter.
2
has
weeks
not
time.
been issued.
The Ashun. None appears for the petitioner. The learned advocate appearing for the alleged contempt submits that steps have been taken to comply with the order dated.
That is what, my lord.
What is the date of the order? Order dated 15th of
19/12/24, my lord.
1912.
24.
15th March 2022. Pustup, let compliance report be filed within a period of 2 weeks from date. List this matter after 2 weeks. 2 weeks, yes. Next. Call the next matter.
দিয়ে দিয়েছি।
বইটা যাচ্ছে
7.
My lord, I was addressing in reply. Now, my lord, on the last occasion, your lordship was kind enough to ask me regarding the position of the Rule 29. Notice, your lordship kindly see Rule 29 of the Central Reserve Force Rules 1955. Your lordship kindly see a member of the force whose appeal has been rejected by a competent authority may prefer petition for revision to the next superior authority. The power of revision may be exercised only when, in consequence of some material irregularity, there has been injustice or miscarriage of justice or fresh evidence is disclosed. So, my lord, when,
This is the scope of revision.
when, and as to how the revision.
Who? At whose instance?
As whose instance this has been given. Next, the procedure prescribed for appeal under sub-rule C to G of Rule 28 shall apply mutatis mundis to the petitioner to the petitions for revision.
So similar
Same.
procedure for appeals
Same.
will be applicable.
Same. Then the next superior authority, while passing the order on a revision petition, may at his discretion enhance the punishment. Then, provided that before enhancing the punishment, the accused shall be given an opportunity to show cause why his punishment should not be enhanced. Then further proviso, provided further that an order enhancing punishment shall, for the purpose of appeal, be treated as an original order, except when the same has been passed by the government, in which no further appeal shall lie, and an appeal against such order shall lie such and such. So,
To which authorities it will lie?
no, not only that, not only that.
Yes.
I made the application for revision. Revisional authority found that order to be enhanced, punishment to be enhanced.
No, you have not preferred any revision.
No, no, no.
Oh,
As you-
hypothetical case.
Hypothetical.
Yes.
As per this provision, a person stuck in the appeal, he filed an application for revision before the authority. Authority, while perusing the petition, found that no, this particular sentence is not enough. Sentence should be enhanced. So he sent a show cause to him. He passed a fresh order. That fresh order amounts to original order, where from appeal lies.
No dispute with regard to that.
Appeal lies. Now, the procedure for doing so. So I made the application, records are not there. Nothing is not there. Only the application. Suppose before authority an application has been filed. Authority has to look into that application materials from the records. That procedure has been given in D. This is not suo motu. Because your lordship can see, the authority has been prescribed here. Who are the authorities? In C.
मीटिंग करने का कोशिश किए थे हमारे मोटे ले जाते नहीं लेते तो हम लोग करने की सोचते हैं। तो ये हमारा 500 पॉइंटर्स हमारे
So according to you,
Because your lordship kindly see, in B, it has been indicated the procedure of appeal should be allowed, should be applied. What are the procedures of the appeal? In typewriting, with stamp, with these, all these paraphernalias are there. But regarding production of records and all this,
C to G.
C to G of 28,
Yes, yes.
your lordship can see every appeal preferred under this rule shall contain all material statements, arguments relied upon by the person preferring the appeal. It shall contain no deceitful or improper language or relevant allegation. It shall be complete in itself. Petitions or appeals filed by the members of the force are not chargeable with stamp duty.
Yes, yes, yes. I've seen.
These are the procedure. These are the things as to how the appeal is to be filed that has been
So
given.
procedural aspect.
Not procedure, as to how the appeal is to be filed. As to how the appeal is to be decided, that's the discretion, that's the procedure prescribed in revision. As to how the revision is to be decided. That is D.
What is troubling Mr. Chatterjee is the proviso after D.
Yes, yes. Provided that in
And
case
now kindly compare this. There are two provisos. One is after C, and
after
another
C,
is after D.
after C,
So
after C is this
whether proviso after D, even if I accept your submission that this is the procedural D is procedure how revision is to be decided, then this proviso after D is surplusage because that proviso is already there in.
No, 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 no.
Can it
Proviso,
take up proviso after C?
second proviso.
No, first proviso.
First proviso, provided that before enhancing the punishment, the accused shall be given an opportunity to why the punishment should not be enhanced.
Yes.
This is first.
Yes.
Then the order passed by the authority is to be treated as the original order.
Yes, yes.
Just
that,
like appeal.
that is there.
Just like appeal.
That is the second proviso. I am on the first proviso.
Yes.
First proviso says that in case of enhancement, show cause is to be given, opportunity is to be given. So then, if D is only the procedure,
Yes.
proviso after D states the same thing, it's a surplusage. Then it will be a surplusage. Kindly compare this proviso
My lord,
with the first
in-
proviso after C.
In that event, your lordship can appreciate one thing. In that event, this order would amount to an appeal again.
Yes, yes. Because C also says. C also
Appeal
says-
again.
So both ways. Let us take a hypothetical case, two ways of the argument. One is revision at the instance of the member of the force. Let us hypothetically consider and revision at the instance of the department. So in both ways, authority has the power to enhance either at the instance of the enrolled member or at the department's instance. And that order will be subject to a further appeal. There is no dispute with regard to that. The confusion is being created because of proviso again added to clause D.
Yes.
Because this is a mere surplusage. If that was there,
No.
saying incorporating this procedure.
Because D contains of both. If order is passed in C.
Mr. Chatterjee, has this provision not been interpreted anywhere?
No.
You
Because
have checked up.
I have checked up.
Your junior has checked up.
Yes.
Not been interpreted.
Not been interpreted. Only thing,
Not been interpreted by any courts.
so far I have checked it out. It has not been. It has not come to my notice.
Because the only thing is it's a central statute.
Central statute
Operates throughout
throughout the India.
So if any high courts have interpreted in one way, that has to be taken into consideration.
Only thing your lordship can see, if it is suo motu, suppose if it is suo motu, then it ought to have been incorporated in the statute suo motu on their own motion, as it has indicated in the CISF rules. Your lordship can see in CISF rules,
The suo motu was there. I have dealt with that. Rule.
yes, on his own motion. On his own motion, this particular word, and your lordship.
That expression I have interpreted in that judgment.
Yes, and your lordship.
There are twofold remedies.
Now your lordship can see another limb of argument. This is one limb when there is punishment, there is inquiry.
Strategy, give me 1 minute. Yes.
Number, in my humble submission, whenever the authority in my application exercises the power under D, call for the record and 40 feet that the punishment should be enhanced, then the proviso should be applied. If the proviso is applied, then it again becomes original order and further appeal to be lied. But your lordship, this has become unending process. Punishment given, appeal preferred, appeal dismissed, revision preferred, authority enhanced, higher authority.
Again appeal. Again appeal, again revision.
Again appeal, again revision. This is unending process.
But the statute says so.
This is an unending process. Absolutely unending process.
Statute says so.
Maybe, but the statute has some limitations here. And it has to be read
Have
purposefully.
ended there. Once it says it's an original order, Subject to
because C says,
Mr. Chatterjee, there is one logic behind that. There is one logic behind that.
then my lord, in
One
that
logic
event,
is, let us suppose you have been awarded a lesser punishment. I'm not saying what is the punishment. You have been awarded a lesser punishment. On revision, either at your instance, whatever it might be, in revision, a higher punishment is awarded. So if you do not get a right of appeal, then you can come to the writ court. Writ court will say, Mr. Chatterjee, I cannot enter into the merits, show me only the infirmity. So this is the original order. Enhancing is a separate punishment. For that, there is a provision of appeal. Because this is the logic for making it an original order, because this the imposition of punishment is by the disciplinary authority.
well, I may interpret in another way. Your lordship kindly appreciate, as your lordship give me the limb. Your lordship has given me the limb. Your lordship kindly see, first I made the application for revision. I made the application for revision for reducing the punishment. In exercise of power under B, 29B, the procedure of appeal has been applied, and in exercise of power under C, the higher authority enhanced. Now, after that, I am filing my revision, further revision. Before
After that, you file
further revision before the authority. D.
no appeal. It is appeal, not revision.
Appeal.
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 Wonderful.
If the appeal also speaks about that order,
Yes, appellate authority retains that.
then where shall I go? Revision. D has to be read in consonance with
Yes,
C.
revision.
Revision. D has to be read in consonance with C. Now, even in revision, the order enhancing should continue. Then this notice has to be given.
Yes, enhancement show cause notice has to
No.
be given.
That retention of enhancement,
Yes.
what has been given by the earlier revisional or appellate authority,
Yes.
if that is retained, then
Yes.
this, suppose in original order, only stoppage of increment, the order was there. The appellate revision order given reduction in rank. Appellate authority thought it be no, not reduction in rank.
There is another difficulty. Another difficulty is revision by a superior authority.
Superior authority.
So that order is an original order. So appeal has to be an authority higher than that superior authority.
That has been given in C. That has been given in C. Now I have to read.
C is for revision. I am not on revision. Revision is by an authority higher than the appellate authority.
Yes.
Now that revisional authority
Now, my dear Lordship,
enhances the punishment, which becomes an original order. Then, if it is subjected to appeal, because second proviso states about appeal, then that appeal cannot be an authority lower than that of the revisional. It has to be an authority higher than the revisional authority.
Your Lordship, kindly take C1, CI.
CI, yes.
Suppose this order has been passed by the Inspector General.
Yes.
Inspector, as in this case, DIG has asked for inquiry. Now DIG is the
higher authority. That is why I am saying.
Inspector General.
So then,
No.
the Inspector in General, then you will have no other.
I'm coming to that.
Forum.
Inspector General passed the order for revision. Then who is the appellate authority? Next page. Special Director General or Additional Director General.
If the Inspector General
pass the order for revision, enhancing the punishment,
then which clause?
Then it will go to the Special Director General.
No.
Your Lordship, kindly see. If
the same has been passed by the government in this case.
General, if the same has been passed by the Inspector
Government,
General,
no appeal shall lie, and an appeal shall lie against an order shall lie to the Inspector General if it has been passed by the Deputy Inspector General, to the special director general or the additional if the same has been, it is inspector general, then it is to be special director general.
That I'm submitting.
Yes.
That I'm submitting.
Yes.
So appeal is to lie before this authority.
Yes.
Appeal is to lie.
Yes.
Now, after this appeal, I have the power to prefer revision. Because appeal has been rejected, A has been given, appeal has been rejected.
Yes.
This is D. He brought the records. Records have been brought. And he issues the notice regarding enhancement of punishment. The punishment which has already been enhanced by the revision or appellate authority. Because that is now the original order.
Yes.
That is now the original order. Stoppage of increment has been changed to reduction in rank. That is the original order. Now, for retaining that original order, is this show cause notice is given. Not anything else. Not a new one. I have to read C with D.
So according to you, after C, there is a right of appeal.
Right of appeal.
So from that order,
Revision.
the revision is D.
D. That's why I have given, I have indicated your lordship has given me the limp. I have missed the limp, your lordship has given me the limp. Your lordship, kindly read it again. Your lordship, kindly read it again. This is the only answer. Yes.
No, reduction in rank. Reduction in rank.
Then that authority again has the power to enhance.
No, the
Proviso is there.
proviso
after
is
D.
there. Enhance. Enhance.
So
Again
then
appeal.
after enhance,
Again appeal. What can be done? That's the lacuna in the statute. They did not say no appeal lies against that enhancement. They did not say. Here, if this written no appeal lies against this order, then stop. They did not say so. Unending process.
no, appeal is a creature of statute.
Yes.
So after this, after D, there is nothing said that there is a further right of appeal.
That your lordship may say.
It will end at D.
And end.
End at D,
Yes.
nothing further.
Nothing further. That may be. But that is, I have to do it after C, not prior to C.
So according to you, this D is a stage
After C.
after proviso to C, second proviso to
Yes.
C.
Yes.
C is power to enhance. Second proviso gives you a right of appeal. So after that is D. Yes.
Now your lordship kindly see another limb of submission. This is relating to when a punishment has been given, inquiry has been done for offense committed. Now, my lord, this is their consistent stand. What offense I have committed? I have written disrespectful language to my superior officer. That is their consistent stand.
One representation in the representation.
I have made. Yes, I have given.
You have said many things.
Yes, even if I accept it, I have given very well. To what extent they can go it? The specific provision in the statute?
Yes.
Standing order though. আমার স্ট্যান্ডিং অর্ডার কোথায় গেল? ওখানে আছে। বার করে দিচ্ছি না, দাও। ওটা যদি তোমার আঁকা জোগাটা আমাকে দাও।
Violation of the cases rule আছে এখানে।
Now your lordship, can you pardon me for marking?
That will help the court.
Now I am become old. I have to mark it and read it.
That will help the court, Mr. Chatterjee. You have also marked those portions which are against you. Must be at the time of.
No portion is against me on this too.
Yes.
14.10.
Yes.
While every officer. Now your lordship, kindly see the first page. It's standing order. Standing order 4/2015. যেটা আপনারা রেফার করেছেন।
Yes.
First page, your lordship, can see the preparation and maintenance of annual performance appraisal report, etc.
1.4.
And your lordship, can see 1.4.
14.10.
No, first of all, your lordship,
1.4.
1.4 first page.
Yes.
The new appraisal system requires certain attitudinal changes. The reporting and reviewing officers should not shy from mentioning shortcoming in performance, attitudes, and overall personality of the officers reported upon. It should further be realized by the reporting and reviewing officer that the whole objective is to develop the officer. An exercise of report writing is not intended to be a fault-finding process, but a development one. Now, your lordship, can you see 14.10? While no, election নেই কেন সেখানে থাকবে? This is your document. You have indicated 14.10.
Yes.
While every officer has a right to file representation in order to safeguard his legitimate service interests, this right should never be mistaken as an opportunity to malign senior officers or make insinuating remarks against their conduct and integrity. The representation should generally contain all material statements and arguments on which the representation rely and must not contain any disrespectful or improper language. Every representation where representationists are still in service of the government shall invariably be routed through proper channel. Then 14.12. The commandant or DIG or IG, as the case may be, must withhold a representation which contains any disrespectful or improper language. However, in every case in which representation is withheld, the officer preferring the representation should be informed of the reasons for it in writing under the intimation to the next higher authority. He may be told if he redrafts his representation in proper language, it can be considered. So,
According to you,
may I
if they have
put this?
found, according to them, it contains certain disrespectful or improper language, they should have withheld that same and asked you to make a fresh representation.
May I put this question to us? What is the scope for making inquiry on this? Nothing. Because this is not an offense. Now, your lordship, kindly see the act itself. What are the offense? It has been indicated there. Section, your lordship, kindly see the act. First provision, this act, Central Reserve Force Act, 1949.
Yes. Which section?
Section 9 and 10.
Yes.
More heinous offenses, less heinous offenses. These
Yes.
are the more heinous offenses A to L.
Yes.
Nothing has been indicated writing disrespectful languages and heinous offense. At least I have not seen.
Yes.
Now, if your lordship, my learned friend may say D. He may try to attract your lordship's attention on D, 9D. Directly or indirectly holds correspondence with or assists or relieves any person in arms against the state or omits to discover immediately to his superior officer any such correspondence coming to his knowledge. This is something else. This is not this disrespectful language or any other thing. Section 9 puts it, Section 9. Section 9 of this Act, 1949 Act. আমি রুলস বলিনি কি বলছেন নতুন পুরনো নতুন বই কালকে কেনা হয়েছে
Yes.
আচ্ছা then your lordship kindly come to section 10 less heinous offenses.
10, 11.
They may say
Insubordination.
or now your lordship kindly see in the charge memo they have indicated insubordination or this thing, and finally they have written this insubordination is writing disrespectful language. Your lordship kindly see the charge memo. No specification of insubordination.
उसमें जो एलिगेशन लगा था करप्शन का
insubordination. Senior का बात नहीं मानता insubordination. कोई GO है सर.
So censure is also a minor punishment.
Minor punishment. Against whom no appeal lies.
Against that, no appeal lies.
My lord, to that
If no
extent,
appeal lies, the question would be whether revision is maintainable or not.
yes. No, certainly not, as per these rules. Now, my lord, to that extent, even if I challenge the order of censure, I could have, because that is also, they cannot impose me.
Censor.
Censure, because
You have not challenged, Mr.
no,
Chatterjee.
I have
the
not
censor.
challenged. I have not
You
challenged.
have not challenged.
I have not challenged. No, my lord. In that sense, according to them, censure is not a punishment.
But censor falls within the
Within this
minor punishment.
But there is no provision for appeal or anything. And your lordship, the charge is also for minor punishment. 11.1. 11.1.
charge in the charge memo.
Charge memo.
Minor punishment.
Yes, your lordship, can you see? Say 101A, article of 1 charge of the writ petition.
Yes.
Your lordship, can you see the last sentence? The sentence begins with the language as well as the said act. The act is writing improper, being done by by the said personnel, is unbecoming and serious disciplinary matter. Where from the gated, I do not know. The action of file number such and such against the service condition as reflected in the CRPS Act 1949, as well as allied rules and regulations, and such is the same is punishable under section 11.1 of the Act. 11.1, your lordship, can you see? What is 11.1?
11.1 does not include censor.
Censor? 11.1, the minor punishment is this.
Yes, but it does not include censor.
No.
Censor is in 4. Sorry, 3.
No, 11.1 is everywhere.
No. 11.1
Yes.
is A, B, C, D, E.
Yes.
So there, this is 11.3. Censor is 11.3C. So it is not 11.1.
Yes.
So they are now trying to impose 11.1
11.1.
over and above 11.3C. 3C speaks of censor.
Ah.
So charge is not for censor.
No.
Charge is for 11.1. That means any of the penalties falling within
What are the
clauses
penalty?
A to E.
Your lordship, what are the penalty? Reduction in rank?
Yes, A to E.
A to E.
So censor is not within that.
No.
Censor is within 3C.
Now, if at all, if it is a crime under section 9 and 10, if it is not a crime under section 9 and 10, then the question of all these proceedings does not come into play.
The second charge to that.
Now, your lordship, can you see the second charge?
That is for quashing of the charge memo. That is for quashing of the charge memo. Now we are on the jurisdiction aspect.
Yes.
Quashing, they may say it's a factual aspect.
Now, the contents of the charge is not for all these crimes. Your lordship, can you see? I'm very. Your lordship, 101B, your lordship, can you see?
Yes.
Prior to that, your lordship, can you allow me to read the entire article 2 charge, 101A?
Yes.
This is to inform that file number such and such, sub-inspector, Malik, etc., in terms of section 11.1 of the CRPF Act, has disobeyed the direction of superiors, neglect of his duties, reminiscence in discharge of his duty. Further, the said person has raised certain allegations against the ghost, assistant commandant, retired, as working in central zone without any evidence, and are false and baseless in nature. Void, later dated 5/3/2018, by passing prescribed channel, by addressing the same to the Honorable Prime Minister, Home Minister, as well as other constitutional posts. The person has also raised serious allegations as regards the birth certificate of C. Ghosh, working in the central zone without any credible evidence. Thus, file number such and such, battalion, is time and again raising false and baseless allegations against C. Ghosh without any cogent evidence. The same is tantamount to insubordination, thought such act, and dignity and majesty of the said force is being severely compromised. and such behavior of the said person is punishable under section 11(1) CRPF Act, read Rule 27
কে পাস করছে এটা বলুন
DIG Ajmer range.
91টা
Now your lordship kindly come to page 91.
Yes.
This has been passed by the DIG Ajmer range.
'91, yes.
লাস্ট প্যারাগ্রাফ দেখুন বলবেন আইজি সেন্ট্রাল হেডকোয়ার্টার
Now your lordship kindly see.
ইট ওয়াজ টাইম বার্ড
Your lordship kindly see there. This representation has been given. No, this is the earlier representation.
Yes.
Which has been time
So what was rejected? What was rejected?
rejected.
রিপ্রেজেন্টেশন এই যে পাসিং 18 চার্জটা যেটা বলছে ইট হ্যাজ অলরেডি বিন রিজেক্টেড
Oh, here lordship kindly see 101B. The charge is relating to 5/3/2018.
101B?
Is writing of letter of 5/3/2018.
Yes.
5/3/2018. And 5/3/2018 has already been rejected.
ডেটটা ভুল করেছে আগের
It is 3/5, it is with 5/3, page 91.
আগে কথা
Yes, yes.
Once the charge application has been rejected or the representative rejected, can they put any articles of charge against that after rejection? I did not prefer any appeal against that.
ওই আইজি
And it has been done by the IG.
আইজি সাবঅর্ডিনেট
IG has rejected that.
Yes. Anything
And-
more?
And man, this is, even if I accept that I have written certain disrespectful language, then where will go? 1410, 1412, there is no provision. And your lordship can see, imputation of the charges, I could not include it in,
আমরা মানে এটা ফাইল করার পরে তারপরে
I could not, because I got it after that. আমাদের charge, এটা দাও, মোটাটা। I am giving one document to your lordship, that's their document.
ইনকোয়ারিটা
The inquiry proceedings, inquiry officer has incorporated here the imputation of the charges.
But Mr. Chatterjee, I cannot go to
No,
that.
I am
only on the.
I am not asking you, your lordships, to go to make any inquiry on that. Only thing that imputation of charges also did not specify what are the insubordination. Only thing they have given, the only thing they have given that writing disrespectful language. Even if I write disrespectful language, 1412 will apply. No question of making inquiry or anything. If there is no such thing, then this letter should have been gone. Page 93.
Yes.
n- 93A, English version.
So there were two charges. One is of 3rd of
310.
October.
310.
That has ended in censure, and Article 2 has been rejected earlier.
So gone. Everything gone.
Yes.
Where is
Anything,
the scope for 93A?
anything more?
জাজমেন্টে দেখো
Oh, this judgment, this is a well settled principle that whatever in the statute, court cannot add or modify anything. That's a well settled. This is the judgment. I have gone through the earlier judgment, old judgment of the Supreme Court. My learned junior has shown me the recent judgment. Well, that is 2010, volume 8, SCC, page 24. Your lordship kindly come to
2010,
volume 10.
2010.
Volume 8, SCC,
Yes.
page 24.
Paragraph.
Paragraph 20 and 21. But 21, there are two paragraphs, 20.1, 21.1 and 21.
You have a photocopy of that.
Photocopy I shall give. I am giving the original. Your lordship can see paragraph 20. The principles of statutory interpretations are well settled, where the words of the statute are clear and unambiguous. The provision should be given in its plain and normal meaning, without adding or rejecting any word. Departure from liberal rules by making structural changes or substituting words in clear statutory provisions under the guise of interpretation will pose a great risk, as charges may not what the legislature has changes may not what the legislature intended or desired. Legislative wisdom cannot be replaced by judges' views as observed by the court in someone in different context. This is the judgment has been given when the
You will
procedure.
be relying upon paragraph 21.2.
Yes. 21.2.
If one construction will lead to an absurdity,
Yes.
while another will give effect to what common sense would show was obviously intended, the construction which would defeat the ends of the act must be rejected even if same words used in the same section and even the same sentence have to be construed differently.
Yes.
Indeed, the law goes so far as to require the court sometimes even to modify the grammatical and ordinary sense of the words. So according to you, the common sense
Prevails after CD. Because C, when enhancement made, it has become the original order. Then D comes. Prior to that, D never comes. So these are the procedure taken by them for conducting the
strategy,
inquiry.
can I keep this for
Yes,
some
yes,
time?
yes. Yes, definitely. My lord, may I file one short written notes of argument if required? If required, I can
You
file.
can file. If you want, you can file.
If required, I can file.
I've also filed the.
You will also file. When?
You will also give me 1 week time.
Ashun.
Oh, 1 week. 7 days.
No, 1 week, I to बोल रहा
1 week, 7 days.
हूँ. 1 week is to
Which one
change.
you prefer? 1 week or 7 days?
1 week is to change.
Heard, Mr. Chatterjee. Acha, heard na. Mr. Chatterjee, Learned Senior Counsel, last order ta ki. HON'BLE Learned Advocates বলা আছে, তাহলে তোকেই বলি। The learned advocates for the respective parties have concluded their submissions. Stop as paid for the learned advocates for the respective parties. List this matter after a week to enable them to file their written notes of argument. So you can do one thing.
Your lordship kindly keep the standing order.
You can include that in your written notes. That will be better, and you include a photocopy of that judgment also.
My lord, I shall. এটা কার? আমারটা ওদের।
Yes, call the next matter. এই বইটা রেখে দেবেন, আছে তো? ঠিক আছে,
বইটা দিন, বইটা দিন।
যশ সাহেবের আছে।
ঠিক আছে,
আছে?
16.
I appear to the petitioner. But this was, my lord, taken up day before yesterday, my lord. There was an error in
on
the.
Mr. Siddiqui's ground, it was adjourned.
Was not there. In fact, I missed the list, my lord.
Yes. What is this matter?
And I'll humbly pray before your lordship, my lord, there is a direction for filing of the affidavits long back, but the affidavit is also ready. It was only to be affirmed. Lordship, kindly grant me 2 weeks time, my lord. I'll just affirm the affidavit, come back to your lordship.
What is this issue?
My lord,
E-way bill.
E-way bill. Yes. E-way bill. E-way bill, there is a clerical error, my lord.
Yes, if that is so, whether there is any necessity to file a, he says the appellate authority, if I faintly recollect, according to him, the appellate authority has also accepted that it's a clerical mistake, clerical error, because mistake is with regard to the number of the vehicle, description of the goods, everything.
No, my lord. E-way bill had also expired. That is also
Yes,
the case.
E-way bill also expired.
And
He
more than 24 hours.
Since the circular does not contain
That was his submission. According to him, the circular does not contain this, that particular item of mistake. So the appellate authority refused to grant them relief.
But the
That was
appellate
the only reasoning. I have not opened the papers. I have heard him.
Appellate authority has
So
given
if that is so, whether there is any necessity to file any opposition?
Lord, Mr. Ghosh, when he was there in the panel, he had prepared the affidavit. I found it when I was taking out the brief. So since it is already prepared, my lord, I'll just file it because the department wanted to.
All right. Otherwise, we will be in
I'll
difficulty.
be-
When?
Within a week, I'll file it, my lord.
Mr. Siddiqui Lanet, Senior Counsel. For the state.
Lord, I'm being led by Mr. Adi.
Yes. He wants 1 week time because according to him, the affidavit is ready. So we will be filing the affidavit because it has been prepared because he is representing an authority. He will be in difficulty unless he files that. Mr. Siddiqui learned additional government pleader. Huh?
Only one thing, Lordship, I have argued twice this matter and then these things have happened. Lordship, let it retain its position. That
Yes,
is
so
all.
it will retain its position. Mr. Siddiqui learned additional government pleader seeks an extension of time to file. There was a direction to file affidavit.
There was a direction. There was a direction.
Seeks an extension of time to file the affidavit in opposition. First up, as prayed for by Mr. Siddiqui, the time to file affidavit in opposition is extended till 15th of January.
15th of January.
First up, reply thereto if any be filed. 20th. 22nd, it will appear under the same heading.
Get from it.
Can it be on 24th? 24th is a
Not
holiday.
24th extended ছুটি আছে
24th,
But
Then after
26th
26th.
after 26th.
27th.
27th.
Mr. Siddiqui will not be available on 24th.
Many of the lawyers, my lord, will be taking chance. I'm grateful, my lord.
So that week, 24th will be a holiday.
My lord, we are thinking about it.
Resolution.
Yes. 27th, yes.
Item 40, Mr. Rai Mukherjee is appearing for the petitioner, Your Lordship.
Yes.
The father's taken ill, he's been hospitalized, Your Lordship. If I'm praying for not this week, Your Lordship.
As prayed for by the learned advocate for the petitioner, hearing of the matter stands adjourned for this week. Next.
Grateful, Your Lordship.
41.
Appearing on behalf of the petitioner, my lord, led by Mr. Sayan Sinha.
Petitioner.
Yes, my lord.
Yes. Who is opposing you?
My lord,
Yes. What do you want?
the state was supposed to file their affidavit, my lord.
Pass over next.
42.
42, yes. Pass over.
43.
Lordship, Mr. Rahul Karmakar is leading me in this matter. He is on his legs on court
To start,
number 8.
madam. Yes. You can start. Yes. Who is opposing you?
May I file the affidavit of service?
Nobody is appearing.
What is appearing still?
Sanjoy Saha. Opposition has been filed.
Okay.
Hey, Advocate General, why? Nobody is
The
appearing
state is
for
the
the
party.
state.
State is the party in this matter, Lordship.
Yes, you are appearing.
I am for one of the respondent, West Bengal Mineral Development.
West Bengal Mineral Development. You are the answering respondent.
No, Lordship,
State.
after 2021 rule came into effect, West Bengal Mineral Development has been designated as the nominated authority for grant of sand mining lease. In this particular case, the lease was granted in terms of 2016 rule, West Bengal Minor Mineral Concession Rule. I
Yes.
believe the petitioner has challenged an order passed by the additional district magistrate.
So according to you, the
Which
state is the answering
it is
respondent.
it is appealable order.
Who is appearing for the state? Nobody is appearing. What is the order under challenge? Page 61.
Yes, Lordship, on page 61.
Page 61 is under challenge.
Yes.
Here, Lordship, the petitioner has paid for exclusion of the lockdown period from his sand mining lease. The lease was executed for 5 years. During the existing period of the lease, the COVID pandemic, and that's why for a certain period, from the aberrament it appears he could not enjoy the entire 5 years. That's why this writ petition. He made a representation.
Where is that? Representation has been considered.
No, Lordship, I stand correct. It is not.
Order.
It is yet to be considered.
Later dated. The representation.
Lord,
Yes.
আমার নোটিং কোথায়?
এটা তো শোরুমের নতুন।
Yes. Lord, the writ petition seeks extension of time under the lease deed granted in my favor. On the verge of
So you are praying for giving effect to a particular clause in the lease.
my lord,
Is the writ maintainable for that?
statutory lease. Statutory lease.
Statutory lease.
Statutory lease terms and conditions are also provided in the statute itself.
Yes.
There is no question of private or contractual relationship coming here because I did not have an option.
Which clause you want to?
Lord, kindly comes to বলছি দাদা আমি পড়ে এসছি একটু বলি page 15 the lease deed starts.
Yes.
I'll take your lordship first to the lease deed and thereafter also to the corresponding part in the rules which forms the basis of the lease. Lord, kindly comes to clause 5 at page 46.
Yes.
Failure on the part of the lessee to fulfill any of the terms and conditions of this lease shall not give the state government any claim against the lessee or be deemed a breach of this lease, comma. Insofar as such failure is considered by the state government to arise from force majeure, and if through force majeure the fulfillment by the lessee of any of the terms and conditions of this lease be delayed, the period of such delay shall be added to the period fixed by this lease. In this clause, the expression force majeure means, it's an inclusive definition, act of God, war, insurrection, riot, civil commotion, strike, earthquake, tidal storm, tidal wave, flood, lightning, explosion, fire, such and such. Now, my lord, I am invoking this force majeure clause on two accounts. One is for flooding. During the monsoon period, there are notifications by way of which the mining activity has stopped. Notification issued by the state government. And the second is the COVID period. These are the two periods, my lord, I am asking for extension. Invoking, my lord,
Where is the decision rejecting your prayer? That is under challenge.
Yes.
Where is that?
Lord, kindly comes to page number 61.
69.
61.
61.
This notification is under challenge.
No. You have made a prayer for extension.
Yes.
Where is the decision rejecting your
Lord,
prayer?
there is no decision because the
That has not been done. It is pending.
That application is pending.
By this notification, Lord, I challenge this notification because by this
According to you, this is coming in your way.
The fate is sealed. The application, my application's fate is sealed. Kindly, my lord, comes to this.
Yes.
Whereas the Department of Industry such and such has implemented new sand mining policy 2021. And whereas this department wants to facilitate the transition into the new framework such and such, and whereas the Department of Finance data has given now.
So this is,
Now-
Mr. Kormokar, subject to correction. This is on account of transition from an old framework to a new framework.
Not exactly.
For that is the circular.
Lord, I shall.
Wants to facilitate the transition into the new framework in a smooth manner by extending. So they are trying to.
The framework came into effect from July 21.
Yes.
The framework came into effect from July 21. So, my lord, there was no reason why February 22 will be held to be a stand for transition. The transition period, I tell you, Lord, why.
They have, accordingly, they have said that they decided that it could not be completed. So they have on their own extended.
I'm trying to clarify that. Lord, during the COVID period, all of us had suffered.
Yes.
Now, my lord, at that point of time, even the Supreme Court had extended that limitation period. Suo motu. Now, my lord, taking cue from that, and there is another notification.
Mr. Kormokar, I follow your argument, but this cannot come in the way. This they have voluntarily extended because, according to them, they wanted to transition from old system to a new system.
They say because I am liable under this notification, my application cannot be considered.
Where is that decision?
Lord, there is no decision.
So
they are saying that I am bound by this, nothing more than that.
Where is that?
Lord,
that is your submission. Where is that on paper?
Lord, nothing has been given on paper.
So
my application is still pending on
I
the
can
basis
direct
of
them
this.
to consider that. Take a decision.
Very well, Lord.
Because this does not take into consideration your prayer for extension. You have prayed for extension on XYZ ground.
My lord.
That is not the reason, because they have voluntarily extended it on certain other grounds.
There is no order at such.
For transition, because administrative difficulties. They are trying to transition to a new framework. Initially, they might have thought, yes, it would be done within the time. But in February, they might have thought, no, the new framework could not be implemented within that. That can be implemented. So they have extended it voluntarily till 31st of May.
Because the rule was notified in January 2020.
So for whatever reason.
That's why in the month of February, this
they
extension
have
was
thought
voluntarily
that
given.
it cannot be the new framework, could not be.
Kindly clarifies that this notification does not, Lord, affect my Lord representation. Kindly clarifies that, and Lord directs them to represent, consider the representation. That the application, my application is, Lord, at page 59.
Who will consider?
Additional district magistrate, because the lease was executed by additional district magistrate in favor of the writ petitioner.
Now, my learned senior friend cannot say anything. He does not. He's only a party formal.
I am
nothing more
assisting
than
that he is the
nothing
authority
Assisting
who
your case.
Nothing more
will
than
consider.
page 59 is my representation.
Where are the reasons? You have stated which paragraph?
Lord, reasons, Lord, there is no reason, no order itself.
No. Your ground for extension.
Lord, kindly comes to.
No, you said some flood. Where is that?
Yes. Lord, you may agree. Outbreak of coronavirus, the third paragraph.
Yes, you may agree.
You may agree that in view of the outbreak of
that is COVID-19.
Yes, that's COVID-19.
Yes.
Thereafter, due to declaration and such, the entire period was
Election.
It went to election.
Election, how does mining activities affect Mr. Kormokar?
Lord,
COVID,
and also, Lord, the monsoon was also there. Lord,
where is that? You have not stated
might
that.
be they have, it has.
No, Lordship, may I just clarify? The monsoon period, every year, it is there in the rules. 3 months during the monsoon period.
For that flood and other things.
It is in terms of the central government notification.
But in any event,
July, August, September, these 3 months mining
what is
activities.
this, Mr. Kormokar, this gazette notification 18th January?
Lord, that is with respect to the Ministry of Forest. Kindly comes to, turns over to page 58.
Shall not be considered for the purpose of, there is a notification.
Yes. Kindly comes to page 56 is the notification.
So according to you, by virtue of this notification, you are also entitled.
I'm also entitled. They say
1 year.
Yes.
No, that is for COVID-19.
Yes, for COVID-19, Ministry of Forest had issued this notification, and they said that it applied to those regions where the forest department is acting, not to mining leases.
But there is no decision with regard
There is
to
no
that.
decision. The only problem was this
So you
notification.
wanted to claim benefit of this circular.
Not only this, I rest my case entirely on that clause 5.
Yes, clause 5,
Read
But
with this.
read with this.
Read with this.
Ashun.
And Lord, this notification, Lord, I'm challenging. The reason is this was affecting my Lord representation.
Ashun. The petitioner
Lord, may I?
has challenged the government order dated February 28, 2022 in this writ petition. Stop. The petitioner, আচ্ছা একদম উপরে লিখে দেবেন, affidavit of service filed in court today is taken on record. In spite of notice, none appears for the state. Full stop. You are for the 7th respondent.
Yes.
The 7th respondent is represented by its learned advocate. ঠিক আছে, তারপরে তাই এটা petitioner claims that by virtue of a registered lease deed dated April 6, 2017, executed in favor of the petitioner with respect to plot number MGB 46 within Mouja Bhatpara in the Subornorekha riverbed under under police station Gopi Ballabpur, Roman 2, in the district of Jhargram. The petitioner was given the right to excavate sand from the said property. First up, the lease deed was executed on 6th of April 2017, and the same was in force till, what was the period?
5 years. Lease
2022, and the same was valid for a period of 5 years from the date of execution.
It is from the date of registration.
What was the date of registration?
6th April 2027. It was valid till 5th of April 2022.
কি বললাম 6th of April for a period of 5 years from the date of registration. The petitioner claims that on account of COVID-19 pandemic, certain restrictions were imposed for carrying out the mining activities, as a result of which the petitioner suffered losses as the said property could not be utilized for a period of about 20 months. Paragraph. Mr. Kormokar, learned advocate appearing for the petitioner, placed reliance upon a gazette notification Now, placed reliance upon a notification dated January 18, 2021, which was published in the Gazette of India Extraordinary by the Ministry of Environment, Forest and Climate Change in support of his contention that the period from April 1, 2020 to 31st of March 2021 shall not be considered for the purpose of calculation of the period of validity of the state lease period. Mr. Kormokar further placed reliance upon clause 5 of the said lease deed, clause 5 under part Roman 8, clause 5 part Roman 8 of the said lease deed, which deals with force majeure, FORCMAJUERE, open caps, close cap. Force majeure clause in support of his contention that
Actually, it should be part 9, Roman capital 9.
Roman capital 9.
General provisions, clause 5 of part 9.
Oh, sorry, yes, I have missed one page. Part 9, part 8, na, part 9. Which, ki bollam? This with force majeure clause. That on account of COVID-19 pandemic, the period of delay should be added to the period fixed under the said lease. First up. Mr. Kormokar further submits that though the petitioner submitted a representation praying for extension of the lease period well before expiry of the said lease period, such prayer was not considered by the respondent authorities. He further submits that the government order dated 28th of February 2022 is so further submits that the government order dated 28th of February 2022 puts an embargo upon the authorities to extend the to consider the prayer for extension of the lease period. Paragraph. Heard the learned advocate appearing for the 7th respondent on such submission. None appears for the state. Paragraph. The government order dated 28th of February 2022 was issued by the Government of West Bengal Department of Industry, Commerce and Enterprise, Mines Branch, in order to facilitate the transition into the new framework in a smooth manner by extending the validity of leases expiring till April 2022 for a certain period of time. And and it was decided that all sand mining lease expiring till April 2022 be extended till 31st of May 2022. Full stop. The purpose and object of the government order dated 28th of February 2022, as it appears from a bare reading of the same, is only to facilitate implementation of the new sand mining policy, 2021, and the same has nothing to do with regard to the prayer for extension of the lease made by the petitioner on the ground by invoking the force majeure clause in the lease deed. Full stop. The prayer for extension of the lease submitted by the petitioner by a letter dated 11th of, it's January or February, page 59, 11th of January, Bodha. January, initially it was 2, thereafter it struck off 1. 11th of January 2022, before the additional district magistrate and district land and land reforms officer, Jhargram, is still pending for consideration. First step. In view thereof, this court directs the additional district magistrate and district land and land reforms officer, being the 6th respondent, to consider the representation of the petitioner dated 11th of January 2022 for extension of the lease period on the grounds as stated in the said representation, and to dispose of the same by passing a reasoned order after affording an opportunity of hearing to the petitioner or his authorized representative. The reasoned order shall be communicated to the petitioner immediately thereafter. The entire exercise shall be completed within a period of 4 weeks from the date of receipt of a server copy of this order, along with a copy of the representation dated 11th of January 2022, which is appearing at page 59 of the writ petition. Stop. It would be open to the petitioner to place reliance upon any notification in support of its case for extension of the lease period at the time of hearing before such authority. With the above observation and direction, the writ petition stands disposed of. No costs. Urgent photostat certified copy. Next.
Forty-four and 45.
I beg to appear for the state, my lord. My learned friend was supposed to take instructions from his client.
Lordship, I beg to appear for the petitioner's lordship. I'm led by Mr. Shobu Shadi's He is on legs before the circuit. I shall continue. He will join. I shall start. He will join in the meantime.
What
Lordship,
was the instruction which we are asked to take?
Yes, Lordship. The instruction is I was the contractual employees. The matter was contractual employees replaced by another
But in the
contractual.
selection process.
Yes. Through the WTL. Through the
Yes.
WTL. My instruction is, Lordship, that we will not eager to go before the WTL.
All right.
We will go upon the merits, whatever will be there.
Yes.
We'll go through. This is the matter.
Yes, you start.
Yes, Lordship. Now, on the last occasion, Lordship, I have placed whatever the documents was there.
Location intervened, everything went out.
Yes, okay. Yes, yes, Lordship.
Yes.
Lordship, the petitioners before this court, Lordship, we are the DEO, data entry operator, appointed by the Food and Supplies Department directly after go through the Lordship the selection process. The interview was there, computer test was there, and the written examination was there. The appointment was for the initially for the 6-month, Lordship. The post of DEO. It was a contractual post, Lordship. Now, Lordship, after the 6 months, what happened, Lordship? Another notification was published by the WTL for the food corp for the Lordship West Bengal Food and Supplies Department, that for the same post the contractual employees will be appointed for the same purpose of work, Lordship. That is for the ration card job. The post name was the DEO, Lordship, and they have initiated the proceedings, Lordship, when I was in the job in between. Now, Lordship, on the last occasion,
Your case is that they are trying to replace one set of contractual employees by another set.
this is one, Lordship.
That is
And
your contention.
this is one. And next, Lordship, on the last occasion, Lordship, I have placed the notification, the mother notification, Lordship. There is a clause, there is a provision which says that if there is requirement, the ongoing continuing project is there. If there is requirement, Lordship, re-engagement can be done. Re-engagement can be done. So our contention before this court is, Lordship, that since we are the DEO, we are the experienced one, we have discharged our functions for the 6 months, Lordship. Now they have published the notification which is on state by Justice Arigna Mukherjee. The notification is state for now. Now, Lordship, we are before
No
this.
further steps taken
No,
for
Lordship.
appointment.
No.
You
Further.
are continuing.
No, I'm not continuing. They have not allowed me to join.
Terminated.
Not allow me to join.
It has not been extended.
No.
They were for a temporary period.
Therefore, a
It is not
temporary.
extended.
No, not extended. Now, the only point to agitate before your Lordship is, since there is a scope for re-engagement as per the memorandum.
Mr. Bandyopadhyay, only one thing. If you require, because for data entry purpose, if you require data entry operators, and they were assuming for the present that they were appointed for a different project. It is assumed. But they were engaged. What is the nature of job for which they were engaged was as data entry operators. And if the subsequent notification, maybe for a different project, is also for that data entry operators. So why are you not re-engaging
I'll tell
them?
you.
Because
But
after all, they must
in
be
the
having some sort of
in
experience.
the shortest possible manner, I'll answering to your Lordship, my lord. First of all, the works are not same. I can demonstrate. Secondly, place of I'm coming to it.
Data entry
No, I'm coming to
was-
it. My lord, the answer will be very spicy for the petitioners to take. I give it, my lord. My lord, secondly, my lord, the place of posting is not the same. But notwithstanding anything else, the petitioners, my lord, belong to a group of 597 data entry operators. What we have advertised for is 342. So let them, my lord, come up with the list before your lordship, that out of the 597, let them select. Let them select that who are these 342 that will work here. My lord, my submission on the
according to you,
that is why, my lord, that is why your lordship's order on the last occasion that you come and tell.
the process for re-engagement will be not for the entirety, but a portion of that. Small portion
The
of that.
requirement is different, my lord, but I am making this submission notwithstanding anything else.
Yes.
And
So
that is why
according
your
to-
lordship recorded that order. Now, kindly remember what Mr. Banerjee said. Mr. Banerjee comes today and says, I don't want to participate there.
No, no. Let
Meaning
us-
thereby, I want to take up all this vacancy. Now, then the question is, who? You were a group of 600.
So according to you, let us assume they are 400, you want to take only 200. Which of 200 from
So
400?
anyway, they'll have to go into a recruitment process. We have ensured that to able. They can jolly well go and apply there. But no, they want a preference. They want to earmark these vacancies for themselves. Therefore, first you have to decide yourself that who is coming. How will they decide? How can the petitioner decide that out of this 600, which 350 will come? Petitioners cannot take up that mantle upon themselves. There has to be an independent agency doing it. We have entrusted that to
It's
able.
not more than what.
No, because it is not the same job. It is not oranges for oranges. It is apples for oranges.
Yes.
Well, the skill is the data entry.
Whatever you are saying,
But this is
maybe for ration card, maybe for they
there's
can
a-
be done
but-
because
and
the
my lord,
persons whom you are taking also they do not
Now-
have experience. After all, they have some experience.
now,
in
my lord,
this.
now, my lord, kindly take the other aspect of it. That we give some preference to these people who have already worked with us at some point of time. My lord, that
Because in a recent decision, it has been
no,
held that
but my lord, that
even in case of
that-
contractor, some weightage for
that
this.
leaves out, my lord, the public at large who could have fared better even without the experience. There may be better persons to discharge the job.
There are two things. Experience always counts.
Yes, Lordship,
So some, because in a very recent decision of the Honorable
Supreme Court, yes,
even contractual, the
yes, my lord.
experience which they have gathered while working as
May
contractual
I
employees,
read that
when they will
portion?
be participating in a selection process, some weightage. Same argument can be advanced here also.
But I am assuming that, we give 5 marks or 10 marks for
Anything-
experience.
Anything
Then
whatsoever.
also, someone else who has not worked with us, they may score more than that
Yes,
person.
yes, they may.
So ultimately, my lord, kindly sees the situation. Ultimately, it's thrown open to the public, but that is not what the petitioners are here for. The petitioners say that do not include anyone else, take it only from us. This is where the problem lies. Because if the answer to this is yes,
Mr. Chatterjee,
the
how many
answer
of
to your,
you are how many?
295
that is
the
the
number of
petitioners, that is the petitioners
who have approached the court.
who have approached the court. So that leaves out another same people in the same cluster.
What is that cluster?
That 500, the remaining of the,
Where from do you get that?
I'll tell you, Lordship. But kindly takes page 58.
58.
Yes.
Yes, page 58.
Kindly take the summation.
This 497.
497 is the total cluster. Out of whom some
There
are
are some of these.
there are some of these. In I do not know, my lord, how many are there in the other
They were
petition.
engaged by virtue of page 57.
57.
Yes,
Now, what is the new notification?
My lord, the new notification is at page.
144.
My lord, kindly takes page 1. Yes,
144.
144.
144.
Food and Supplies
This is
Department, West Bengal.
244.
342.
342.
No, this is 342. Yes. So much less.
Petitioners are lesser.
No, petitioners are lesser, but the cluster. I being a welfare state, I cannot stop
Mr. Chatterjee,
someone.
One thing is that if only petitioners are given this benefit, others may be deprived.
No, since they have approached
Because
the court,
all of them are standing on the same footing.
but since they have approached the court, Lordship, considering the fact,
Chatterjee, only because you have approached the court, you should not be granted some extra privilege.
even Lordship, kindly consider a
And
situation.
if it was more, I could have said, or it could have been considered whether all these they can consider. If any one of them chooses not to, yes, they can fill up. But here is the other way around. You are more than what they are trying to take up. So some have to be. So then, why don't you participate in a selection process?
No,
What is there?
Lordship, we have already participated in the selection process.
No. For this new recruitment or
No,
the new
The
engagement.
the
not
only thing is
recruitment.
that this Supreme Court recent judgment, your Lordship has correctly said, Lordship, it says that the true trust of every selection process ought to be find out and select suitable candidates having experience in the related work and fulfilling other criteria from among eligible candidates and to go ahead with appointing the more meritorious and those found suitable.
Yes.
If indeed an individual without having any security of service performs up to the mark and receives commendation from none other than the head of the department who must have closely watched his or her performance, it would occasion a failure of justice to exclude such individual for no better reason than what he or she did not work on a sanctioned post. If indeed such be the requirement, it had to be made explicitly clear in the advertisement without any ambiguity so as not to generate false hopes in the mind of the individual aspiring the public.
Those who have worked, those who have experience, some weightage is to be
And
given to-
petitioners are exactly asking for
Yes.
that relief.
So in the advertisement, some weightage for those experienced
lord.
candidates and others is. So, but this is to be, so you have to participate in that. So whether this for experience, some weightage is to be given, that is a different thing altogether.
My
But
lord,
whether you can be only, since you have chosen to approach this code, whether only you can be re-engaged.
Lordship, this thing is that the law says, Lordship, subject to correction, that unless this is Lordship, they decides not to take the permanent this cadre, they don't decide to recruit the permanent persons in those posts. Till then, Lordship, they have the right to be re-engaged in terms of their earlier
They are
engagement.
completely
qualifications.
temporary, depending on a scheme.
There are some problems in this. One is, let us assume 200 were working. Now, the authorities decide no, maybe for the same. I now require only 100. My requirement is that, but to some extent it has minimized, but requirement is there. Then from that, whom to be excluded, whom to be taken.
Lordship,
There has to be then again a selection.
that's within department, they can do it conduct
Again a selection to exclude some, to take some.
within the department itself.
So if contractual appointees per se do not have any right, if open again contractual, because now everything is contractual, nothing is permanent. So other candidates, you can also compete with them. I don't think there is any age bar, and experience as per Mr. Bandyopadhyay, anything there with regard to
No, that is what distinguishes this. I was just looking for it. Here, in the advertisement, 0.5 marks was there.
Yes,
We are not having that.
for that, that is, I think in
He doesn't want that. Malad, kindly, I'll just put it in my way. Malad, they have challenged the entire recruitment process, this new recruitment process. They don't intend to participate. If they intended to participate, the course of action would not be to challenge it. They have kindly ceased the prayer.
Lordship, because of the clause given by them. Kindly come to
It is
page
not their
59
grievance
once.
that we have not allocated a marks for experience.
They say in their clause in page 59, contract for engagement of manpower can be done.
Page 53.
Page 59. Contract for engagement of manpower can be done by clause 5, Lordship.
yes,
Page 59. Contract for engagement of manpower can be done by the department directorate purely on temporary basis for a period of 1 year or less for development and implementation of e-governance projects, which can be renewed on monthly or yearly basis by the head of the department directorate as per requirement of the project. So, Lordship, this right to get my work renewed is depending on the fact that whether there is the requirement for the project. So it is their memorandum dated 22nd July 2013. Memorandum 5859, and I am governed by this memo. So, Lordship, my right to challenge this entire recruitment process or whatsoever it is arising out of that. So I have a right to be re-engaged or considered for re-engagement till the project is
Mr. Chatterjee, please
subsisting.
give them the right for renewal. Kindly come to the next clause, very next clause, clause
Yes,
number
madam.
6.
The department directorate shall
Disclose in the
disclose.
project report the requirement of software, their number and period of engagement. Approval of the shall be obtained by the administrator as per the existing. So the requirement of the software personnel. So now the department in their project report, they will again reassess their requirement. So initially, maybe at a point of time, their assessment was of 100.
Some may go,
Now is 50. So renewal.
some may go,
Yes.
some
So
may
how to
within them, within the zone.
within
which is
them,
what-
what should be the method of excluding some and taking some? What should be the method?
Lordship, if
And
it,
again, a question of discrimination.
Lordship, that,
Whom to be excluded?
Your Lordship has asked me a very pertinent question that how it should be. There would be three possible result. One, the number, suppose there are 10 candidates within the department working, now the requirement is 5. So 5 has to be excluded. Now for this purpose of exclusion, a test may be conducted within the department.
Yes. So
Suppose
then-
it is 15.
Then again is, yes, more is not a problem. But if it is less, then again a selection.
But
According to you, you
we-
said test. So some sort of selection to
within the department.
Why better candidates from the public will be excluded? Why
if
the state as an employer cannot take better candidates?
from the general public.
Now, that is something, Lordship, subject to correction, which Supreme Court says that unless the better candidates are coming through the permanent process of recruitment, that this cannot be possibly done. Because the
Contractual for
contractual
that-
cannot be replaced by contractual. That's the law, subject to correction. And that was the reason why the first order was passed.
Then everyone who has worked for 2 months, 3 months, or 4 months, everyone has a right to get re-employment over and over again.
Mr. Bandhavate, I'm also party to a similar decision. I have also held it cannot be done.
If necessary, I'll deal with it.
Right.
I'll deal with it. I'll find it out.
Petition bench at circuit.
I'll find it out, Lordship, if Lordship wants.
Court
Second.
Blair, sir.
I'll find it out.
So replacement.
But
that
as
was
far as this
not-
judgment is concerned, it's not applicable.
But that was against permanent post. This is not a
This is
permanent.
not permanent.
So in a permanent post, one contractual, you are replacing that. So in that, there cannot be any question of reducing, enlarging. Post is set.
And there is no, and another thing, there is no continuity. They have worked, they are gone. But they have worked, they are gone today. It is not a continuous thing as if they are there. It is not that we are picking them from one place and putting them in another.
One thing, you have requirement, this is going on. Why are you continuing with this contractual? Why are you not making permanent appointment?
No, my lord,
Everywhere, even in courts,
my lord, your lordship, my lord,
everywhere contractual.
as far as my lord the earlier one is concerned, what I can discern is the time period is such when the National Food Security Act was being implemented. So it is quite natural that at that point of time we required some people to make that transition into e-governance. 2013. As far as what is required today, is the requirement has become different. But with so many EPOS coming and all the digitization of the entire rationing system has
According to
become.
you, for a specific purpose at that relevant point of time.
And it admitted cases that they are not continuing. It is the admitted case. It is not a case where they are continuing.
No, no.
We are removing them.
Their contract was not
Extended. They
extended.
they worked for some period and then they left. Matter has ended there. There has been a severance. Today, when they see this advertisement, then they come back and say that no, I will not go into the open competition.
One thing, one clarification. Your advertisement was after expiry of that period.
Yes.
No,
But this is on 2013. The advertisement is of 2022.
That is within
Let
the
them show, my lord.
Kindly come
They
to
will show.
146.
They will show, my lord.
page.
The page 146, my lord. This was published on 144. It was published on 24/6/2022.
Yes, 9 years later.
And but kindly come to page 146, last paragraph, last to last paragraph. This has an approval of the finance department.
Yes.
So it is immaterial.
Group such and such dated 23rd March 2022 when I was in service.
No. That is different thing. But this advertisement, when you were when your period ended.
I was in service when this was issued. Lordship, when on 24/6/2022,
you were in service.
I was not. But on 22nd March 2022,
So
I
when
was.
the finance gave approval,
I was in
that is for approval of this project.
So the requirement was there on that day. Project was approved, Lordship, on the basis of the necessity of the requirement. There was a requirement to fulfill.
Mr. Bandyopadhyay, you said that these are the two different projects.
Yes, and the requirement also much more rigorous.
That these are the two different projects.
My lord, your lordship, if your lordship kindly take the first one, 2013, that is page 59.
Page 59. Yes.
Kindly take the first few lines.
Most of the departments. State government are now implementing.
Different e-governance projects.
Kindly, my lord, I'm sorry, my lord. Kindly take 57.
57. 57. Yes.
The department has decided to engage temporary additional data entry operators at district level offices on contractual hiring basis for ensuring prompt and time-bound services related to Duare ration, ration card, life cycle management, paddy procurement, and other regular establishment work for a period of 6 months, with effect from 1st of November 2021 against monthly consolidated remuneration of 13,000. This is the only requirement in 2021, the old one. Now kindly take the new one. That is page 144.
Yes.
Food and Supplies Department requires the services of 342 data entry operators in various offices under the Food and Supplies Department on temporary basis. Out of these, 244 data entry operators are required to be engaged in field offices. This was not there in the earlier one. Under the Directorate of DDPS, while 98 shall be assigned to various offices under the Directorate of Rationing. Just pausing here for a moment. DDPS is for the commodity, food grains, and rationing is for the kerosene. That is the bifurcation. On temporary basis for 1 year or till requirement is over, whichever is earlier. These DEOs will assist. Now, this part is not there in the earlier one. The DEOs will assist the office staff and or perform duties in the office of data entry, scanning documents, processing the initial works related to the ration card and other online services in the portal. The field offices are located in various blocks, municipalities, subdivisions, and district headquarters where these DEOs will be required to provide the services. Then kindly take eligibility criteria. This is important because in 2021, this eligibility criteria was not there. So this is the first screening that these people have to cover. Candidate must be a resident of the concerned district where they will be posted. As on 1st of January 2022, a candidate should be within the age of 18 to 40 years. Candidate should be a graduate in any discipline. Candidate must possess a certificate of at least 6 months course duration in computer applications in MS Office. However, candidates with a certificate of 1 year course duration would be preferred. In typing test, they must have a net speed of 30 words per
some experience of or certificate, some weightage.
Well, 6 requirements are there in the new advertisement. It was not there in the earlier one. But if I may use the word, the 2021 had a much more casual approach to it. Now it is much more stringent. The requirement is very specific, location is very specific, work is very specific, and most importantly, there are various exercises to be undertaken. These petitioners will have to first disclose that out of the both the writ petition taken together, how many qualify in these 6. Then the actual pool can be received. The petitioners have not undertaken any of these exercises. Directly coming and saying contractual cannot be replaced by contractual. But these requirements are not there at all in the earlier one.
Lordship, kindly come to page 50.
Just excellent. Then shortlisting is there in the next page. Etc. So,
yes. Lordship, kindly come to page 57 once.
Yes, 57.
57. As my learned friend was telling about the criteria and the eligibility criteria.
Yes.
Kindly come to paragraph 2. The candidate shall be selected as per eligibility criteria as laid down in memorandum of Finance Department number such and such, shall take prompt action for selection of the engagement of
this eligibility criteria?
Yes, my lord, kindly come to page 60.
60.
My lord, 14, professional fee remuneration for the software personnel, data entry operator, minimum qualification and experience, graduation with certificate in computer applications. So, lordship, it was there.
Only this.
And now, kindly compare it with the page which has been shown by my learned friend, 145. 144. Lordship, eligibility criteria, candidate must be the resident of the concerned district where they will be posted for the other ration. As on 1st January 2022, candidates should be within the age limit of 18 to 40 years. Candidate should be graduate in any discipline. Candidate must possess the certificate of at least 6 months. So, Lordship, here there was a graduation with certificate in computer applications. Here it makes that minimum 6 months. Computer applications I have got, all of us. In typing test must have the speed of 30 words per minute. So, Lordship, these are based on the skill of the computer applications. So, Lordship has correctly earlier was distinguishing that what is the necessity of the data entry operator. And my learned friend was saying that it's not the replacement of the orange with the orange and apple. Lordship, ultimately the skill has to be tested. The skill is the computer applications. Whether it is required for the dual-relations implementations or it is required for any other official implementations as given under this law. Lordship, this can be done on the basis of the skill. So I have got the skill and the qualification is the same. This is the same memorandum. And the same memorandum which provides the clause 5 which says about the re-engagement, the scope of re-engagement.
Exactly. That is the same engagement of the qualifications, and this is the same of 5.
So, Lordship, this is something which is creating my right, Lordship. Kindly 59, 60, and it has to be read with my learned friend's reference, that is 144.
Even the salary structure is same.
Even salary structure, Lordship, is also same. So, Lordship, this, if we test these two, Lordship,
So we were selected, Mr. Chatterjee.
Lordship, with a process, through proper selection process, computer test, then written examination was conducted, interview, and oral was taken.
Where is that requirement?
My lord, I'll show. No, এখানে কোথায় requirement ছিল? Notification. Lordship, kindly come to this. No, requirement কোথায়? পরীক্ষা হয়েছিল? Lordship, this was done. It was not given there. We have taken the awardment to that respect. Paragraph 5 is the
Paragraph
5. Appeared in oral interview and computer test. Page 41. Paragraph 5. So specific awardment.
affidavit has been filed.
Yes, my lord.
How they have dealt with paragraph 5?
My lord. I'll read it out. Position. My lord, para 5 has been dealt in paragraph page 9.
Yes.
It says that without waiving the opposition, now with regard to statement in para 1 to 13 of the said petition, save what are matters of record, anything contrary to and or inconsistent therewith is denied and disputed. It's evasive, Lordship.
Yes.
This is the affidavit submitted by one Abhijit Moitro.
Yes.
This is one. So for long 2 years we are waiting before this court. Lordship, kindly till they decide to engage the people regularly or permanent employees, kindly allow us to be considered for the re-engagement.
Want to cite any decision?
Lordship, these decisions, Lordship, old decisions, earlier decisions, I'll be citing on rely on this. And if you, Lordship,
What proposition?
proposition is that, Lordship, first proposition, I have two proposition. One, a set of contractual employees cannot be replaced by another set of contractual employees. For that, one, তুমি আগেরটা দাও আগে একটা একটা করে।
We have relied upon this earlier also.
Earlier we have relied on this. This is Hargut Pratap Singh, 2007, 13 SCC, 292. And Lordship, it's a small judgment, Lordship. And there is another judgment. This was earlier 1985, 4 SCC. 1985, 4 SCC, 43. And I would be relying on paragraph 2. We therefore direct the state government to take immediate steps to fill up in accordance with the relevant rules the vacancies in which teachers appointed on an ad hoc basis are now working, and to allow all those teachers who are now holding these posts on ad hoc basis to remain in those posts till the vacancies are duly filled up. The teachers who are now working on such ad hoc basis, if they have the prescribed qualification, may also apply for being appointed regularly in those posts. The state government may also consider sympathetically the question of relaxing the qualification of the minimum age prescribed for the appointment to those posts in the case of those who have been victims of the system of the ad hoc appointments. So, Lordship, this was 1985. Now, Lordship, another one. This is 2022, 15 SCC 540, Manish Gupta and another versus President. Copy to though. Here I'll be relying on Lordship. Lordship, paragraph number 5 onwards.
Give me a
White
minute.
government circular
Mr.
dated.
Chatterjee, give me a minute.
Yes, ma'am. No. Minute.
2215, yes.
Yes, my lord, in 2015, that is Manish Gupta, I rely on paragraph 13 and 14. Para 13 onwards, it says a perusal of the advertisement dated 24 June 2016, issued by the Principal Government of Kamla Raja Girls Postgraduate Autonomous College, Gwalior, which is at Annexure P2, the appeal paper book and the advertisement dated 2nd July 2016 issued by the Principal SMS Government Model Science College, Gwalior MP, which is at Annexure P3, the appeal paper book would show the appointments were to be made after the candidates has gone through due selection procedure. I have done that. Though Sri Natraj Lanet ASG has strenuously urged that the appointments of the appellants were at guest lecturers and not as ad hoc employees, from the nature of the advertisements, it could clearly be seen that the appellants were appointed on ad hoc basis. It is a settled principle of law that an ad hoc employee cannot be replaced by another ad hoc employee, and he can be replaced only by another candidate who is regularly appointed by following the regular procedure prescribed. Reliance is respect can be placed by judgment of this court in Ratanlal versus State of Haryana and Hargut Pratap Singh versus State of Punjab. Both I have relied on. Now, in view of the matter, we do not find that an error was committed by the learned single judge of the High Court by directing the writ petitioners to continue to work on their respective posts till regular selections are made. We, however, find that direction issued by the learned single judge of the High Court that the writ petitioner should be entitled to get the salary in accordance with the UGC circular is not sustainable. The advertisements themselves clearly provided that the selected candidate would be paid the honorarium to be determined by the said committee. So, Lordship, so far the engagement is concerned, it is the consistent view, subject to correction, of the Honorable Supreme Court that the contractual employee will continue in the service. And Lordship, one thing I want to point out, as it has fallen from your Lordship also, that now Supreme Court is also saying, and other states are also doing it, they are going away from the contractual engagement, contractual work. They are insisting for the permanent employees to be appointed everywhere. Like State of Odisha has already taken the policy decision in this regard. So these judgments are passed in that premise, Lordship, subject to correction. I beseech your Lordship to consider these three judgments along with the, I am covered by their own memorandum dated 22nd July 2013, paragraph number 5, as well as the minimum qualifications and others. And Lordship, so far, the query was fallen from your Lordship on the last occasion regarding the the sanction post and others, whether the posts are sanctioned posts.
Posts are not sanctioned.
These are not now creation of this kind of job, because as it has fallen correctly from Mr. Bandopadhyay, that these are for the new requirements. Now state will have to consider in future that to engage the permanent people for those posts.
Yes, so posts, there is no sanctioned posts as on this day. So now there is only contractual appointment. It is not a case that contractual appointment is made against sanctioned posts. It is a case, there is no post, some appointments are made on contractual basis, but not against sanctioned posts.
Lordship, this then I was referring to that paragraph number 26 of the recent judgment, where I said that the only thing is whether the post was sanctioned.
26 of 2022.
Lordship, this is 26. I am not carrying the copy of this judgment. This is the recent judgment of the Honorable Supreme Court that is reportable till now. Lordship, this is passed by Justice Dotto.
Yes, what is the date of the order?
Lordship, I'll tell you the date of the order is, Lordship. This is date.
This is 24, just I think.
This is date is 29 November 2024.
Just
paragraph 26 I want to rely, because
this is with regard to experience aspect.
This is a sanction post, experience and other aspect. Whether it is important.
That is the difference.
Because this kindly, may I read it, Lordship?
One thing, appointment of contractual, on contractual basis against sanction posts.
Yes.
And another thing is that contractual appointment without there being any sanction post.
Lordship,
so here we are on a case where contractual appointment not against sanction posts.
Yes, Lordship.
Whether this principles can be applied in this case.
Yes, my Lord, I will refer to page, paragraph 26. If your Lordship.
Of that judgment.
Yes, because this covers, in my understanding, Lordship, subject to correction, the true trust of every selection process ought to be found out and select suitable candidates having experience in the related work and fulfilling the criteria from among eligible candidates, and to go ahead with appointing the more meritorious of those found suitable. If indeed an individual without having any security of service performs up to mark and receives commendation from none other than the head of the department, who must have closely watched his performance, it would occasion a failure of justice to exclude such individual for no better reason than that he or she did not work on a sanctioned post. So, Lordship, this.
No, that is the entire. If that is the judgment, that was on an issue whether some weightage is to be granted to a person who have worked on contractual basis, not against sanctions.
Lordship,
I think that is the.
Lordship, the issue was, Lordship, whether the sanction post can be used as a ground to discriminate someone to give the leave.
Yes, that is because that was a case where contractual appointments were made against sanction posts. Now the authorities have sought to fill up that regular post by way of a regular selection process. Now the question arose, those persons who have performed as contractual appointees against that post for a considerable length of time, and they have acquired experience, whether this experience can be done away with saying no, nothing, or some weightage is to be given for that.
May I come back on
that
this?
That is the issue in that.
Yes, my Lord. May I come back on the question of sanction post, whether this, if it is required, I will. Otherwise, Lordship, this is my submission. If your Lordship wants me to address your Lordship.
No, I could not follow. Sanction post?
Whether the issue related to sanction post, whether it is a sanction, since it is, these are not sanction post.
Because the appointment is not against sanction post.
So,
there is nothing in the none of the advertisement.
So, Lordship, the question of sanction post does not arise at all.
Yes.
to
That's
decide
not
this
a
issue.
question of sanction
Yes,
post,
my
but
lord.
these decisions, the decisions which you have cited are all against sanction posts.
Yes,
These
but
decisions
in the light,
were all against sanction posts, contractual appointments, one set sought to be replaced by another set.
but yes, my lord. The question is that, but the ratio of this, lordship, what I say that the sanction post,
Because
post
in
whether
this
it is
judgment, if you
yes.
take up 2022 judgment,
My lord.
paragraph 16.3, this will be clear. The writ petitioners appellants herein would be entitled to continue on their respective posts
Till they are replaced
till
by
they are
regularly
replaced
selected
by
candidates.
regularly selected candidates. Regularly selected candidates has to be against sanction posts. So these all were.
Lordship, the
against
data entry
sanction
operators also has to be, there are sanction posts for data entry
posts.
operators.
But this maybe, but these appointments are not against that sanction post.
No,
There are two things against sanction posts. Instead of filling up by regular selection process, you are doing that by way of
Lordship,
contract.
may I come back on this point,
And
Lordship?
that is
Kindly
the
give me one.
question in case of also regularization.
Yes, and
Contractual appointments appointed against sanction post, they can be regularized, but not those who have been appointed not
now,
against
Lordship,
sanction.
so if I now bottom line this issue in this, if I frame it in this way, that whether the post, whether if they are sanctioned or not, to be considered as a relevant factor to decide this or not. Lordship, may I come back on this issue only on the, kindly give me one day time, I'll address you, Lordship, on this
What are the
issue.
decisions, Mr. Chatterjee? What is these are on sanction. Yes, Mr. Bandhavate. Anything more, Mr. Chatterjee?
But if he has
So for that,
concluded today, I'll
if
conclude
your
today.
Lordship wants me, I can come back on this.
But if he can't,
Otherwise,
then
Lordship, I
no
have
point in starting. But if he has concluded, I can start and complete
He
it.
has concluded. He says that
I have, if
Okay,
any requirement is there, Lordship, I will address on that in reply.
তুমি কিছু দেখাবে কিনা বলো
আর নতুন করে কিছু দেখানোর নেই।
yes.
Yes. So, my lord, page 57. I'm
Also-
concluding my arguments also, my lord, because
May I take your Lordship's
Ah,
kindly
yes,
for
yes.
Mr. Banerjee will be there.
disturb না করলেই ভালো। My lord, those two pages I am not placing again, page 57 and 144, because my arguments on that is that as far as page 57 is concerned, the requirements were not as stringent as required in the new one. This is my first submission. Secondly, the numbers are different, the place of posting is different, and the work also in my submission is different.
Mr. Bandhavate is not different.
It is
Page
not defined.
57, no, it's not different because page 57, it was also district wise. Kindly take up page 57.
Yes, I've seen.
District wise,
We have given the
requirement is
interchange,
there.
but the requirement is not there that the person has to be from the same district. That requirement was not
That
there.
was not
But
there,
what
but
I'm
it was
trying to-
district wise.
What I'm trying to distinguish is that the earlier requirement of 2021 was of a much more casual in nature. I'm not saying it's unnecessary, but the requirement today is much more important, and I am making that distinction from the document itself, because the document, for it cannot be for no reasons that so many eligibility criteria has been put. It is not for simplicity that a distinction had been made that so and so is required for DDPS, so and so is required for director of rationing. Therefore, the specific requirements are there in the new one. The earlier one, that gives to show that the earlier one was to tide over some exigency which arose then and there, and it was required that someone is to be
Without making a
appointed for
proper
6 months.
assessment, without making a proper
Assessment, where perhaps that time was not there, and immediate 6 months for immediate 6 to 1 year, this requirement was there. So this is a clear distinction between the two. Number one. Number
You
two,
are saying some food safety, where is that?
Malad, that is the 2013 finance memo, which my learned friends were placing page 59.
Yes.
But it is that NFSA is not coming out from the requirement, but Duare ration is coming out, but that is page 57. It is mentioned, Duare ration is there. But my lord, these submissions which are being made by the petitioner that state should engage permanent, etc., etc., we need not go into that, because that is not their case. It is not, and it is quite clear that the requirement
Their
is
case is not that kindly make us permanent. It's not
No,
their
no, this
case.
submission, my lord, was made. I understand where it is coming from because Mr. Chatterjee has much more interaction with this society, my lord. So he's saying that no, it's time for permanent postings, etc., etc. But the requirement from the document itself is quite clear that this requirement is also temporary in nature, and we have made it clear that for 6 to 1 year we will take it. In the new process also we have said so. So it is not a permanent requirement for which we'll have to engage someone permanently, and has rightly fallen from your lordship, my lord. This is not in the sanction post that the earlier recruitment was made, because if your lordship takes page 57, the first line itself says that these are additional data entry operators. Kindly marks the word, my lord, additional, in the first line of page 57.
Temporary addition.
Additional. So it is additional to my existing cadre. My existing cadre for the time being of 6 months was not being sufficient for whatever administrative exigency I required at that point of time. So that additional word is very important apropos to the extraneous submissions being made today, which are beyond the writ petition. But still, since it has been made, I am addressing to that. Now, my lord, beyond page 57 and page 144, what I really need to bring to your lordship's kind attention is my affidavit in opposition. If your lordship kindly takes my
But,
case.
without interrupting, page 144, these services of 342.
Yes, my lord.
What is that? Is it against sanction post?
No.
Here it
This
does
is also
not use
temporary
the
basis.
expression
This is additional is not there, but temporary basis your lordship will find in the third line.
Yes, temporary basis is there, but against what?
My lord,
because here you have made a distinction. You have sought to say that it's additional.
that is apropos to their submission that because it fell from your lordship that these are not against sanction post, which is quite clear because the word additional has been used there.
Here 144 nothing has been used.
But even if assuming not mentioned, then also it doesn't inure to the benefit of the petitioners unless both are against the same sanction post. Where there is a one sanction post and I am taking A out and putting B in, both in contractual in nature. So if they were themselves beyond the sanction strength, then they cannot sing the song which are meant for those engaged in the sanction post. It is not for them. It is not their cause to agitate here. So it does not help them. The word additional changes their case from these judgments which have been placed. Now, my lord, if your lordship kindly takes my affidavit in opposition once. Kindly takes a few paragraphs in my affidavit in opposition. Well, kindly takes paragraph 4, subparagraph 2.
In reply, you have filed the affidavit in opposition.
My lord. Opposition है? Page 2.
Page 2.
Oh.
I find the affidavit in reply. Do you have an extra copy of that opposition?
Yes.
You are sure that you have filed the opposition?
Well, I'll have to check the orders, daily orders, my lord. But my lord, my impression is that it has been filed, my lord, in 2022.
2022?
Yes. End of 2022 or so.
Lordship, probably it was not filed, it was handed over to me because the council was changed on several times. Probably, I'm not sure.
There is one endorsement in December 2022, no affidavit in opposition and reply filed. Thereafter, reply has been filed.
No, we have served.
You may have served, but have you filed the opposition? Because this is not on record. And also, I do not find any order recording that you have filed. But their reply.
Well, I'm having an additional copy, my lord. I can supplement it, my lord, subsequently, my lord.
Yes. Yes.
Now, my lord, kindly take page 2, paragraph 4, subparagraph 2.
Page 2, paragraph
4, subparagraph 2. However, the department has taken initiatives to reform the procedure for receiving and processing the various services using IT-based solutions and development of modules for online services related to disposal of pending ration card applications, linking of ration cards with Aadhaar number, and application for farmers registration for procurement of paddy. Earlier, the ration card applicants had only one way of submission of application through physical forms, and disposal of application was also partly manual and partly online. These IT-based solutions are end-to-end online and have provided multimodal facilities and options to applicants for submission of the applications like so and so and so and so, A to F, what are the requirements we have mentioned. In addition to this, the processing and disposal of applications have also been made fully online, and a lot of services have taken away from the block offices to centralized processing center at headquarters. However, some pending work of other seeding, data entry of physical received applications for ration cards related to services were pending at the time in October-November 2021, which were required disposal of these as one-time measure for a short period of 3 to 4 months only. Accordingly, one-time services of some data entry operators were required for a short period. Once this pending work was cleared, the online system was designed to provide opportunities and facilities directly to the applicants and through other modes as stated above, thus not requiring the services of the data entry operators after that. So this is what the requirement was as far as 2021 is concerned. Now kindly take subparagraph 4 at page 4. Whereas it is further stated that as the engagement of 597 additional D, can I read this as 497? It's a printing mistake.
It's
It
497.
is 497.
Oh, yes. 497. Yes.
Chali do.
Lordship can release the other matter because Mr. Bandyopadhyay will take at least 4:30.
I'll take up the time.
Great.
Yes, so other matters is accepting this.
Remaining all matters call on next day.
Whereas it is to further state that the engagement of 497 additional DEOs was one time and purely temporary requirement in nature, and as no approval of the finance department was obtained, the monthly consolidated remuneration was paid from the contingency fund and not from the budgetary allocation.
Finance concurrence was there.
Malak, 2013, this 2013, if your lordship kindly take.
2013, I think
I'll tell you. I'll show that, Malak. Malak, this is the finance memo with regard to engagement of software personnel in e-governance portal on temporary basis. This is the overall circular. Page 59.
Page 59. Yes.
Malak, this is not the concurrence as far as page 57 is concerned. This is an overall memo. It is an overall memo for engagement of software
Only issued with the approval of the minister in charge, food and supplies.
Yes, as far as page 57 is concerned. No.
But page 57, eligibility criteria is as per the
this memo. That is why they have annexed that memo. We have borrowed the criteria from
eligibility criteria.
Yes, but that is not my approval of these posts, which I have made clear at paragraph 4.
Yes.
Next, my lord, will kindly take subparagraph 5 in the same page. The matter related to engagement of 342 data entry operators on contractual basis is a totally separate and different issue. The requirement of these 342 data entry operators was assessed by the Directorate Personnel DP cell of the Food and Supplies Department. The DP cell is mandated to manage the cadres of LDC and UDC and inspectorate staff in the field offices under the directorates and departments. This requirement was assessed considering the regular vacancies and to tide over the shortage of LDC, UDC and inspectorate staff. The proposal to fill these vacancies in the regular manner has already been sent to the West Bengal Public Service Commission. However, since the process of regular recruitment takes 3 to 4 years,
regular posts.
Those are the regular posts.
342 is the regular post.
No, the regular posts are there. Regular posts for those,
there are vacancies in the regular posts for which
it has remained, but the vacancy is not 342. The vacancy cannot be 342. There will be a lot of LDC and UDCs. Considering we have only this many districts.
Yes.
on contractual basis to temporarily meet up the shortage of inspectors and clerical staff was sent to the finance department. Accordingly, the finance accorded its concurrence vide group number so and so or dated so and so, and finally cabinet also accorded its approval for engagement of 342 data entry operators on contractual basis through an agency by outsourcing by period of so and so. So this is the matlab the
Till the filling up of the sanction regular.
of the new one. This is of the
Yes, yes.
342.
Yes, yes. That is again sanction post.
Yes, the earlier one is additional. As rightly fell from your lordship, my lord, which
This is 342.
yes,
Because the notification second, that is the distinguishing feature in the second notification.
second one. That is why
And the purpose is
your lordship has
Never
rightly indicated that is why the word additional is not there. But I had missed that distinction, but that additional word is not there, which is there in page 57.
paragraph 5 of this.
5, yes. Then my lord kindly takes paragraph 7. Subparagraph 7, I'm sorry, my lord.
Yes.
Subparagraph 7. 7, 8, and 9. Whereas the contention of the petition and writ petition is that the department is ending 342 contractual temporary DO by replacing the 597 is absolutely incorrect and concocted with so and so. Subparagraph 7. The process of engagement of 342 contractual temporary DOs through WTL is altogether separate procedure initiated by the nodal cell of this department, that is the Directorate Personnel Cell, who actually looks after the management of the departmental personnel. The method of payment of these 342 data entry operators is also different and as defined in the order number so and so of 8th February 2019 of the Finance Department. The source of fund is also the budgetary allocation of the Finance Department. Well, pausing here for a moment, in the earlier paragraph I have pleaded that these are contingency, this is the budgetary allocation. Whereas the process of engagement of 497 erstwhile DEOs who were engaged by the DMs, DCFS and Deputy Director of Rationing on permission of the IT and Reform Cell of this department was of a very occasional and one-time requirement for different purposes and paid out of the contingency fund available with the department to cope with some exigencies emergent at certain point of time. Whereas it is once again reiterated that the requirement of the set of 497 DEOs was felt as a purely temporary measure to cope with the emergent situation akin to engaging some manpower for painting and repair of the house prior to festivals. Their engagement was done by the district locally. In addition, it is to mention that the 597 DEOs in question were engaged for a seasonal and one-time work for a fixed period of 6 months only. Then can I take paragraph 11, subparagraph 11. Whereas in the present context, the petitioners whose services was purely temporary in nature and whose tenure was fixed and already over are nowhere debarred by the department to apply de novo to the WTL for the engagement of the post of contractual DO. This was my submission on the last occasion. Also, Malad, what your lordship recorded in the last order. This is where the shoe is pricking them, Malad. Now, Malad kindly takes 5C at page 8. 5C at page 7 bottom. Starting from page 7 bottom.
Yes.
With regard to paragraph 14, so and so, so and so, so and so. Then at page 8 top, the petitioners were engaged temporarily on the basis of this department's memo. Order number 8th of October 2021, read with 10th of October 2021 for a different purpose, where it was clearly mentioned that they were engaged for a period of 6 months with effect from 1st of November 2021 for a very special and occasional one-time requirement. If there had been any replacement, then the numbers and places of work of outgoing DEOs and fresh DEO would have been same. But this is where my submission comes, that it is not oranges for oranges, my lord. Then kindly takes 5J at para 9.
That is
at page 9.
Chatterjee says it's oranges for oranges, but 10 oranges for 8 oranges.
But my lord,
orange remains the same.
Even your lordship, my lord, knows we are in the season of oranges. Some oranges are from Nagpur, some are from Darjeeling, but the Darjeeling oranges are much smaller in size. So therefore, in 2021, they did not have to go through this stringent eligibility process. Now they have already entered. They want to shut off the public at large from coming into the picture. So they want to use up this new requirement because they know that I don't require a typing test. I don't need to be fast in typing. I know computer, but I am using computer from my Madhyamik time. But if I have to type, I will not be able to type because I don't have a typing test. Therefore, he says that going by the finance memo of 2013, computer application was required. in his recruitment process. But typing test was not there. So he may know computer like me, but he may be very bad in typing. I know computer, I can use computer, I can use an iPad, but typing speed is very less. Here the typing speed is mentioned in 2023 that the typing speed has to be 60 or 90, it has been mentioned. So they cannot equate, once they have done it for 6 months, they say that everything is same. We have not scanned the addresses of all the petitioners. We might find that out of 200, 100 is from Bankura district. There may be no one from Murshidabad district. Whereas the new requirement is a district-wise requirement. We want to post them in the field offices, and that is why we want local people, so that there is no difficulty in transit. That scanning also, this research they have not done, that who is from which district. We may find only 1% from North 24 Parganas and 0 in South 24 Parganas. So even if they are oranges, they are not the same brand of oranges.
From where?
It depends on they are oranges from which place.
Yes.
Nagpur or Darjeeling.
Yes.
Now, Malad kindly takes 5J at page. Now, Malad kindly takes 5D first. 5D.
Yes.
With regard to allegation made in paragraph 15, so and so, it is stated that while engaging the temporary additional DEOs, VDA department's order number so and so of 2021 and 20, it was clearly mentioned that the candidates shall be selected as per eligibility criteria as laid down in the finance department memo of 2013. It may be noted that the only eligibility criteria of the said order was followed and not the entire order. Then kindly takes 5J. At page 9, last 2 lines, kindly take from the last 2 lines.
This must not be treated as replacement, as the set of work is not the same.
Yes. So those are this is my stand as far as my affidavit is concerned, that there is a sea of difference between what they were doing. The remaining will be mostly repetitions of what I have already submitted. Now, kindly takes as far as the decision which was initially cited, that is Chaudhary Charan Singh, Haryana Agricultural University. This in that judgment, as I have pointed out, in the advertisement, 0.5 marks was already there.
So in that judgment, Chatterjee, you have a copy of that.
I have to do it. With to paragraph in this, I indicating the paragraph.
So Chatterjee, give me a copy of that.
I'll give it to you. It is recorded in paragraph 3, subparagraph Roman capital 9.
You are trying to distinguish by referring to paragraph
3, subparagraph Roman 6 and Roman 9.
Paragraph 3.
But it has not been handed over, Malad. Please, Logic kindly takes a note, Malad.
Yes, I'm taking it.
May I hand over my iPad so that you will
may? I just read that paragraph and
take a note of that.
Yes, my lord. So,
yes, paragraph
3, subparagraph 6 and 9.
What is the cost title?
Chaudhary Charan Singh, Haryana Agricultural University versus Monica, Monika.
All right. Yes.
Roman 6 reads that video and advertisement. The university invited application for direct recruitment to various groups in non-teaching posts. Under the criteria for selection, the advertisement prescribed a maximum of 5 out of 100 marks for experience. It specified that half a mark, 0.5, would be given for experience in the same or the higher post in any department or board or corporation, company, statutory body, commission, authority of the government of Haryana for each year or part thereof which exceeds 6 months but limited to a maximum of 10 years. So 0.5 per year. This was the requirement. And in Roman 9, it says this: a single judge of the High Court, by his judgment and order dated 25th May 2022, ruled that the first respondent was eligible for 0.5 marks for the service rendered by her between 5th May 2017 to 31st of March 2018. As noted above, the decision was affirmed by the division bench. Then the university went up in appeal. But in that factual background, the Honorable Supreme Court is holding the paragraph Mr. Chatterjee was relying on. That was paragraph 26. That a true thrust of every selection process ought to be to find out the select suitable candidates having experience in the related work and fulfilling the other criteria from among eligible candidates, and to go ahead with appointing the more meritorious of those found suitable. If indeed an individual without having any security of service performs up to the marks and receives commendation from none other than the head of the department, who must have closely watched his or her performance, it would occasion a failure of justice to exclude such individual for no better reason than that he/she did not work on a sanctioned post. If indeed such be the requirement, it had to be made explicitly clear in the advertisement without any ambiguity, so as not to generate false hopes in the minds of the individual aspiring for public employment. Any other view would be against both the principles of equality and non-arbitrariness enshrined in
So the
Constitution.
ratio was that if
You are in a non-sanctioned post,
wanted to exclude this in the advertisement, it has to be mentioned.
that only against sanctioned post. No, this person was against a non-sanctioned post. So court says that this will be a travesty of justice. So this is not.
So if you want to exclude them in the advertisement,
Then
you have to exclude.
You have to mention that it is a sanctioned post only. But they have not mentioned that. They have only mentioned that if they have worked for.
Since they have worked, so they have
Yes.
gained sufficient, so they will be entitled to that experience.
So in both counts, this judgment is distinguishable. First of all, my advertisement, second one, notification does not include any marks for experience. So we have not added that. So how it is to be calculated, it is judgment in that sphere, it may be
I
used.
think this may not help because Mr. Chatterjee's case is not that kindly award marks for
Yes, experience.
in course of submission. He has said
Yes,
that we are more experienced, so kindly engage us because the authorities will be benefited by our experience. That is
Yes.
by way of a submission, but
Rather, my submission will be that the question, the consideration of
Bhandopandey,
sanction
anything
post
more?
or not.
Yes, well, two judgments I'll cite. Konta?
I don't need to much.
Malad, I have been able to get one book, Malad. The other one, Malad, I'll just place it and I'll give a copy to a Lordship's officer, Malad. This one I have a
Give me
copy.
the citation.
Yes, Malad, 2006, volume 2 SCC 716. এটা হচ্ছে MP State Agro Industries Development Corporation.
2006 volume 2
2 SCC 716.
That is on what point?
Malad, this is on the point that the appointment being made only to meet an exigency will not confer a right upon them. So kindly takes paragraph 17.
Yes.
The question raised in this appeal is now covered by a decision of this court in MP Housing versus Manoj Srivastava, wherein this court clearly opined that when the conditions of service are governed by two statutes, one relating to selection and appointment and the other relating to terms and conditions of service, an endeavor should be made to give effect to both the statutes. A daily wager does not hold a post as he is not appointed in terms of the provisions of the Act and the rules framed thereunder, and in that view of the matter, he does not derive any legal right. Only because an employee has been working for more than 240 days, that by itself would not confer in legal right upon them to be regularized in this service.
That is regularization. This is, I think, his case is not that of regularization.
Malad,
This was
by
on
this-
regularization, whether he can claim regularization or not.
Malad, kindly Malad considers also, Malad, if they continue by virtue of 2021 temporary engagement, if this legal right is created upon them, that whenever state makes another recruitment process of other contractual employees, which may be distinguished from what nature they were in, merely because it relates to computers, merely because it relates to some scanning, printing, and entry of some record.
Regularization, Mr.
Malad,
Bhandopandey is on a different,
Malad, what
is on a
happens?
higher pedestal that they will gain the status of permanent employees.
Malad, what
all
I'm
those
trying
benefits.
to place is that, Malad, if they want to establish this legal right for every requirement of the state, even if say after 3 years again I give a notification that I want 200 data entry operators. That they say that in 2021, I had worked for 6 months. So I have a legal right to engage here. So ultimately, they enter into the fray for perpetuity. But this cannot be
That
the
is
intent.
to counter the action of the state to fill up these by contractual appointment.
By
They are saying
throwing it
you appoint permanently.
that throwing it open to the general public, but cannot in any way prejudice them, my lord, because I as an employer have a choice of whom to appoint and from which pool to appoint. I am not replacing them. Their work is over. I have a different set of work, maybe, but I cannot keep on inventing nomenclatures. The nomenclature may be data entry operators because it relates to some data, some computers.
Yes.
But the nature is completely different. Malad, the other one, Malad, I intended to show, Malad, is 2005, volume 1, SCC, 639. Malad, I'll
2005, volume 1.
2005, volume 1, Supreme Court cases, 639. Mahendra L. Jain versus Indore Development Authority. Malad, I'll hand over a copy to your lordship's officers, Malad,
Yes,
Malad, as soon as possible. Let us the print party. But I am placing reliance on 37 to 39.
Yes.
Malad, the heading is project work. I'm reading it, Malad. This case involves 31 employees. A distinction is sought to be made by Dr. Dhawan that out of them, 27 had been appointed to a project and not in a project. The distinction, although appears to be attractive at the first blush, but does not stand a moment's scrutiny. As noticed herein before, the High Court's observations remain unchallenged that the project was to be financed by ODA. The project was indisputably to be executed by the Indore Development Authority, and for the implementation thereof, the appointments had to be made by it. If the appellant were appointed for the purpose of the project, they would have to be deemed to have been appointed therefore, and only because such appointments had been made by the respondent would by itself not entitle them to claim permanency. The life of a project came to an end on 30th of June 1997. The maintenance job upon completion thereof had been taken over by the Indore Municipal Corporation. The appellants were aware of the said fact and thus raised an alternative plea in their statement of claim. The Labour Court could not have granted any relief to them as prayed for, as the Indore Municipal Corporation is a separate juristic person having been created under the statute. Such a relief would have been beyond the scope and purport of the reference made by the Labour Court to furthermore, Indore Municipal Corporation was not a party and so and so. In A. Umarani, this court held that once the employees are employed for a particular purpose of a scheme, they do not acquire any vested right to continue after the project is over. Malad, I am not placing Umarani, but Umarani citation, Malad, is also there, Malad. It is there in my note, but I am not placing Umarani. It is furthermore evident that the persons appointed as daily wages held no posts. The appointment thus had to be made for the purpose of the project, which, as indicated herein before, came to an end. The plea of Dr. Dhawan to the effect that the appellants in civil appeal so and so were asked to perform other duties also may not be of much significance having regard to the foregoing findings. However, it has been seen that even the services of one of them had been requisitioned only for the project work. The High Court, in our opinion, was right in arriving at the conclusion that the appellants were not entitled to be regularized in service. But, my lord, the finding as far as paragraph 38 of Umar Rani, that is important for my purpose, that if they are engaged for a scheme, they do not acquire any vested right to continue after the project is over. Once the 6 months requirement is over, as I have mentioned in paragraph 5.2, 4.2 and 4.4 of my affidavit, once the requirement over, their existence in that contractual post is also comes to an end.
All right. Anything in reply?
10 minutes reply, Lordship. Any two, three things, Lordship. Kindly on Monday, Lordship. 10 minutes. Monday, 10 minutes, Lordship.
I will forget everything.
I'll give the notes also. Written
But kindly keeps it tomorrow, my lord. Mr. Chatterjee can do it tomorrow.
10 minutes.
But reply to 2 judgments, both of them are equally inapplicable.
Only with regard to the judgments.
Judgments, Lordship. Lordship has
Reply on facts.
what 3 things, Lordship. One, Lordship, that regarding the continuity and regularization, Lordship has correctly pointed out that. Now, Lordship, the question is why the Supreme Court has.
Tomorrow you are in difficulty.
tomorrow and Friday, Lordship. Tomorrow, 2nd and Friday.
Online
Lordship.
program.
Is to online to possible. Lordship.
Must be circuit bench.
No, not circuit, Lordship. This is
Awesome. Heard Mr. Chatterjee, learned advocate for the petitioner. First up,
fix
Mr.
it on Monday, 10 minutes.
Mr.
Lordship. Go.
Bandyopadhyay, learned junior standing counsel, concludes his argument.
Judgment.
List this matter on Monday date দিয়ে দিন under the heading continuing matters for the
2 p.m.
reply argument of Mr. Chatterjee.
And 2 p.m. Na?
Time I do not.
Grateful. And Lordship, I'll hand over the judgment, copy of the judgment.
Yes, you hand over
Today only.
that judgment.
By the court, sir.
তাহলে Monday দিয়ে দেবো।
The other judgments you have given,
No.
so only these.
Only the
Then my judgment I supply on Monday, my lord. Then everything will be in the file.
grateful.